docket. That is case number 105457, Daniel L. Stuckerman and Kathy S. Stuckerman, trustees et al., v. the City of Basehor, Kansas.
Your Honor, before I begin, I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes is granted.
May I proceed?
You may.
And I'm ready for argument. I think I misstated my entry. I apologize.
No problem.
Ladies and gentlemen of the court, this is an appeal of an annexation from Basehor, Kansas. I'd like to address 4 issues today, if I may. The first is whether the legislature intended to change KSA 12-538 when it changed KSA 12-538 to add reasonableness as a basis for a legal challenge. Second, whether the statutory requirement that boundaries be described means that boundaries must be described correctly. Third, whether the city's proposal for police services was adequate. And finally, whether the city's proposal for streets and infrastructure was adequate. Let me turn to that reasonableness question first, if I may. In 2005, the legislature changed the annexation statutes to broaden the scope of review to state that a landowner or a city may challenge the reasonableness of an annexation. Prior law had held that that was not appropriate. The Sabatini case, the Clark case, and others said we do not consider that. There are a number of reasons this court should find that a plenary review of reasonableness is appropriate. First, plain language of the statute. That's always our starting place in any kind of statutory analysis. It says reasonable, and that's what it means. Secondly, there's a presumption that the legislature does not undertake meaningless legislation, and that has been recited in the context of a 520 annexation in the Dillon case. Perhaps as importantly, maybe even more importantly, we need to look at the history of this legislation. Now, we have recited the conference committee report brief in several places. We've included it as appendices in a couple of places in our briefs and petition for review. That conference committee report brief in general says, number one, the purpose of...
Can I pause you? How do we get around some of our case law that says we can't consider conference committee reports as legislative history?
We get around it by looking at the Clark case, Madam Justice. The Clark case specifically admonishes us to look at legislative history, not just legislative intent, which is slightly different, I will concede, but legislative history. And the Clark case specifically says we must take into account legislative history. And in fact, in the Clark case, this court used a legislative research memorandum, not specifically a statement of a legislator, but a memorandum, very like what we are urging here. In fact, in this case, there is a note to the predecessor statute that was debated, House Bill 2229 and House Bill 2230. The note from the Legislative Research Department contained the same information. The summary of legislation at the end of the session contained the same information. Moreover, Your Honors, I would be disingenuous if I did not represent that conference committee report briefs are a critical component of the context and history of legislation, and I cannot overstate that. These reports are perhaps the most significant component of the legislative historical context of a bill. In fact, they are heavily relied upon by legislators. And to consider otherwise is to simply deny reality. In fact, on occasions, rare occasions, but occasions, that is all the legislators have before them. Sometimes the final bill is not complete, and all they can rely on when they vote is the brief, the conference committee report brief. Therefore, if we are to follow the history of annexation, we must consider those things. Thus,
Counsel, in the Clark case, had the court said the language in the statute is unambiguous, but nevertheless they looked at legislative history?
I beg your pardon, Chief Justice?
Did the Clark court say we find this statute unambiguous, but nevertheless we'll go ahead and look at legislative history?
No. In the Clark case, there was an argument that by creating the earliest incarnation of the service extension plan, somehow that made the entire legislation unenforceable because it was impossible to discern what was going on with the other provisions. Rather, I think the appropriate jumping off point is the Dillon case authored by yourself, Chief Justice, where it was very clearly stated the time-honored canon of construction. If a bill is unambiguous, it's unambiguous. We enforce it as it's written. And this is, I say a bill, if a statute is unambiguous. This statute is unambiguous. It, if I may quote, KSA 12-538 says, any owner of land may maintain an action challenging whether the service plan was whether the annexation was reasonable. That's the plain language of the statute.
So you would call our attention to the conference committee report only in the event we would say we disagree, we find the statute is ambiguous?
Well, if it's unambiguous and reasonable means reasonable, then you don't have to go any further. I think it is still supportive. And I think it's always helpful to look at the legislative history and say, yes, the plain and unambiguous language of the statute says what it says and means what it means. I don't think you necessarily have to stop there. It's always reassuring to go further.
Do you think the
although
statute...
yes, ma'am.
I'm sorry if you hadn't finished that answer.
Yes, go ahead.
Is the statute ambiguous when read in context of the Clark decision? And I say that because the Clark decision discusses reasonableness, but appears to do so in the context of saying that a statute is unreasonable if it is unconstitutional. And that is the litmus test. And it seems that test of reasonableness is different than what we apply in other contexts, such as zoning or other similar contexts. So do you think that creates an ambiguity?
Not necessarily. First of all, if we interpret Clark, if we use the Clark interpretation, that the legislature, by saying reasonable, really meant unconstitutional. Actually, Clark had 2 points: reasonable or exceed statutory authority. And if we say, well, it really just means unconstitutional, that then takes us to the canon of construction, the presumption that the legislature does not enact needless legislation. In other words, for us to say what the legislature meant was what Clark meant, reasonable means unconstitutional, means the legislature did a needlessly redundant act. And that we presume that's not correct. Secondly, constitutional and reasonable are not synonymous in any common sense way. If I may say this, nobody's ever had a spouse say, honey, you're being unconstitutional. But honey, you're being unreasonable. It's a pretty common sense use of that term. Unreasonable is a much broader term. Are unconstitutional statutes unreasonable? Yes, I think we could say that. But are unreasonable statutes unconstitutional? No, we can't say that.
Excuse me, isn't your better argument that the statute doesn't say whether the statute is reasonable or whether the court's interpretation of the statute is reasonable? The words are whether the annexation was reasonable.
Of course you're right.
And so the constitutionality of the statute doesn't impact whether the annexation was reasonable, does it?
Constitutionality of the statute.
Clark dealt with the constitutionality of the statute, didn't it?
Well, as I understand your question, I'm sorry. The issue is whether the use of the term reasonable as applied to an annexation means the annexation itself was unconstitutional. Clearly, unconstitutional annexations would be unreasonable. However, my point is that we are focusing on the underlying annexation itself, and for the legislature to have said, you have a remedy. You have a remedy to ask a court as to whether or not the annexation was reasonable. Clearly, the legislature didn't mean unconstitutional. All acts of government that are unconstitutional or unlawful. They already had that right. A second point that's important to note is that the Clark court said by unreasonable, that usually refers to exceeding statutory authority. Well, that would make KSA 12-538 internally repetitive or redundant. It already says exceeding the authority is unlawful. Clearly, the legislature didn't mean that. It wouldn't say the same thing twice in companion sections. Again, such a reading is needlessly redundant. And again, it's contrary to the presumption of change when the legislature pardon me, enacts a statute.
Counsel?
Yes.
Let me clarify, if I can, the kind of the nature of your variety of arguments. So are you saying that other than procedural irregularities, there are substantive irregularities that make the annexation unreasonable?
Yes.
So the procedural arguments are separate and apart from the substantive?
Well, I think they can be, no, Your Honor, I think they can be read together.
Okay, that's
this-
what I was getting at.
Yeah,
So-
this court has repeatedly said, in this and many other contexts, that we need to read these statutes in pari materia, and that is an appropriate approach.
So
But
we I believe we have law that tells us that procedural irregularities are supposed to be viewed through the lens of substantial compliance.
Yes.
Does that also apply when we're looking at substantive irregularity?
There's no precedent to guide us on that whatsoever. There's no precedent to guide us on any of this whatsoever. But I don't think that is raised in this case because the fundamental issue of unreasonableness in this case is the premise that underlies the entire annexation statutes. Going back to Clark, this court said, really what we're talking about is to identify for people what benefits they will receive and what costs they will incur. And in this case, substantively, as well as procedurally, all we can identify is that they will get no benefit that they don't already have, and they will pay through the nose. Mr. and Mrs. Steckerman estimated close to $1,400 a year just in real property taxes and just in franchise fees alone, not including the other exactions the city may have. The overall subdivision, I should say the Homes Association, over $110,000 in real property taxes for precisely what they have. That's substantively unreasonable. What's procedurally unreasonable is they can't really know what they're getting, and that's addressed in our other points, of course, but they don't know what police services will actually be provided. They don't know what it's going to cost. Those are more in the nature of procedural flaws, although what's substantive and what's procedural is a bit difficult to define. In any event,
So
yes.
I just need to clarify, are you saying then that the only test for reasonableness is if they are receiving more benefit than the cost?
No, that's not the only test, but a simple starting point is a cost-benefit analysis. That's analogous to manifest injury that we find in 521 annexations, county-assisted annexations, that was suggested by the city in its brief. When we look at manifest injury, we talk about the imposition of burdens without a commensurate provision of benefits.
Do we have
And that's precisely what we have here, Your Honor.
Do we have a statutory interpretation problem there because that language is in that county annexation statute, but it is not here?
Well, that's true. That's absolutely right.
So how do we
The
import
legislature,
that?
simply by trying to determine what reasonable means. The legislature only provided one guidepost for reasonableness. And let's talk about that for just a second. That same statute, 12-538 says when a city is contesting an annexation, then the court should look at the effect of growth upon that city. Now, that has to mean that the legislature was contemplating some kind of plenary review by a court. Otherwise, that statute doesn't make any sense. Fortunately or unfortunately, in that case, the legislature said when it's a city, this is one of the factors you should look at. But the legislature put no limit on a court, and I'm not suggesting a court has a limit. I'm just suggesting that when we search the whole scope and history of legislation, we can determine several things. One is that every time the legislature has addressed this issue, it has enhanced the protection of landowners. Except possibly this time, the city is arguing the legislature put it in neutral all of a sudden, and that doesn't make any sense. Secondly, the key purpose of annexation statutes is to protect the rights of landowners. That otherwise we wouldn't need them. Just say go ahead and annex at will. And then third, as I say, going back to Clark, the benefits received and the costs incurred is a theme that starts to resonate as far back as Clark. We look at all those factors and we can discern, and we should discern, this court ought to discern, that some kind of cost-benefit analysis is called for, in addition to an overall review of the procedural and other substantive factors involved. I don't think there's any indication the legislature put any limits on what a court can look at. In fact, contrary, with all due respect to the Court of Appeals and the fine work they did and the delightful oral argument I had with them, I think they're simply mistaken. The legislature did not intend to limit review, it intended to expand review. Yes, Chief Justice, you'll have to ask a question.
If we're to look at reasonableness, and you keep talking about a plenary review, what prevents us from substituting our judgment for that of the city council in this instance?
You can't substitute your judgment for them entirely because you're stuck with the record that they created.
But do you have any standards that would guide us in determining whether their action was reasonable, besides looking at the cost-benefit analysis you've already articulated?
I think you can look at the entire sweep of 520 annexations. Look at the 16 requirements. Did the legislature intend for those to have teeth? Well, clearly so. They just added those in 2005. Those 16 requirements would be part and parcel of any understanding of reasonableness. I think, again, to use a traditional interpretation of annexation law, number one, we look at the legislative history, and number two, we read the statutes in pari materia, and number three, we look at the history and context of annexation law, which is to consistently enhance and broaden the rights of landowners, then we look at it through that lens. Now, what the court can look at to consider unreasonable, I think will vary from case to case and what the facts are. In this case, the most critical component is the cost-benefit analysis. But in this case, a secondary component is the complete lack of information on really the only two services that the city will provide that are not already being provided: police services and streets and infrastructure. There's simply a startling paucity of information in that regard. In short, the legislature clearly intended a very broad review of reasonableness. I will concede it would have been lovely and easier on the bar if they had said what all that included, but they did not do so, except with respect to one situation when cities are contesting an annexation. And so, Your Honors, I would respectfully ask that the court give force to the literal language of the legislature, give force to the legislative history of this bill, give force to the sweep of legislation as it has taken place throughout annexation history, and require a review for reasonableness.
What would, in terms of your cost-benefit analysis, what would the city have to provide in your mind to be in compliance with street enhancements, increased police protection? What would they have to provide the landowners? What information?
With respect to police protection, the scholarship makes it pretty easy. They just have to say how many patrols they're going to add, what services they're going to add, and what's that going to cost. Once again, this is not new news. If we go back to Clark, Your Honors, Clark had a specific statement where the police services would be improved. There was a family, as I recall, a family domestic services unit, and there was a building protection survey unit. Those are enhanced services. There's nothing here in this record. We have a police department is all that it says, essentially. With respect and secondly, you got to know what it's going to cost. If the city isn't actually going to spend any more money, you don't have to be a cynic to see through this. The city's just getting way over $100,000 and doing nothing it has to pay for.
Does every municipal service have to be enhanced?
Every municipal service? No.
They
just have to get something for what they're getting. In this case, virtually all what we would consider municipal services are provided privately. They're provided through utility providers, or they're provided by the county. One of the problems we have with annexations is the roles of cities versus counties has morphed since the 19th century when this topic of annexation came up. Kansas City, Kansas, and Wyandotte County are the same thing now. They overlap. In this case, the county was providing law enforcement services cooperatively with the city. After annexation, the city will provide law enforcement services cooperatively with the county. It's not much of a change, if any. In this case, the county was maintaining the streets. Now that will change to the city maintaining the streets, although at what cost and in what fashion is really anybody's guess. All other services.
Some representation, though, that the county didn't really have a plan for maintenance of the streets or the gutters or anything else, but the city does. Could you respond to that?
Well, that's not entirely clear from the record, I don't believe, Your Honor. the city said it had conducted I think it was called a street, it was an acronym like CPI or CSI, an index of the condition of the streets. But it didn't tell us what they were, and it hasn't done it for Cedar Lake. The information in the record from a resident of Cedar Lake who was a county commissioner was that the county had recently re-asphalted the streets. So that, I think, leads to the inescapable conclusion. These are perfectly good streets. They're probably not going to have to spend much, if anything, for years, but they're going to get a lot of money. In the short term, it's an absolute windfall for the city. In the long term, it's anybody's guess. Again, going back to Clark, with the little plan, the first year, as far as I know, approximately the first year plans were provided for. This little plan said there are X number of miles of asphalt, X number of miles of concrete, Y number of miles, I should say, Z number of miles of unpaved streets. We've talked to public works officials. It costs on average a certain number of dollars per year, per foot or per mile, I don't recall, to maintain those streets. There was actual data. That's what engineers do. That's what public works directors do. That's what should have happened here. And that is both procedurally, because it doesn't follow the statute, and substantively, because it doesn't provide the substantive information, flawed. I'm way out of time unless anybody has any further questions.
Do we have any further questions of council? Thank you, council.
Thank you. I'm grateful for your indulgence.
May it please the court, Patrick Reeby. I'd first like to start out with the standard of review that my colleague talked extensively with you about. If we go back to year 2005 when the KSA 12-538 was enacted, as you all know, at that time there was a long line of cases concerning zoning decisions, namely began with Golden versus City of Overland Park. And this court has repeatedly indicated that when a statute is passed, it's presumed that the legislature was familiar with the line of case or precedent. And so with regard to Mr. I do agree with him on a point that the legislature was trying to do something when it enacted this new statute. But the city's position is that the only thing the legislature was doing was to tell the district court that it could review the reasonableness of an annexation similar to a zoning decision. This court recently in 2011...
Could I clarify that?
Yes.
You're saying that 12-538 tells a district court that it can apply the Golden Rule to an annexation? Is that what you're saying?
No, because I think zoning has different factors, different criteria. What I'm saying, Your Honor, is that the level of deference given to the governing body is the same as it is in zoning. This court recently in 143rd Street Investors, that's a 2011 case, this court examined how a court should review a rezoning decision. And this court indicated that the zoning authority is entitled to the presumption of reasonableness, and the landowner challenging rezoning bears the burden to establish by a preponderance of the evidence that the decision was not reasonable. This court again in 2013 in Friends of Bethany Place versus City of Topeka, again, you stated the appropriate standard, and that standard is this court's, well, this was interpreting KSA 60-2101, the appeal statute for governmental decisions, but this court said, long held that a district court reviewing a political subdivision's quasi-judicial decision such as this one is limited to determining if the political subdivision's decision fell within the scope of its authority, was supported by substantial competent evidence, or was fraudulent, arbitrary, or capricious. So the trial court in this case, I believe the trial court got it right. The trial court the first thing the trial court did was took up the standard of review. On page 4 of the trial court's decision, the trial court indicated as to the standard is to determine whether the party with the authority in annexation matters, which is the municipality, the executive branch, the executive authority of the municipality, and in exercising their responsibilities, did so in accordance with the law within their authority, and did so in a reasonable manner. Going on, the trial court indicated, if I were to disagree about whether I think it's a wise decision for Cedar Lake Estates to become a part of the city of Basehor, that's not the right standard. It's not for me to decide. It's to decide whether the executive authority of the municipality made its decision in a reasonable manner and can support that decision. So then, after citing or going on, the trial court also indicated it believed the legislature did intend for there to be more of a review of an annexation decision than what was in existence prior to KSA 12-538. And again, the trial court stated again on page 15 of its decision, they, meaning the legislature, certainly did intend that the court, if it was going to review this, exercise additional review by determining the reasonableness and set out that the cities needed to provide a plan for their annexation, but just not in the degree of specificity and scrutiny as is suggested by the plaintiff. Then if you look at the trial court's decision, on pages 15 and specifically pages 19 through 22 and page 26, the trial court took up the arguments that Mr. Orr offered up, and the trial court assessed the reasonableness, and candidly, the trial court said, you know what, this could have been construed differently, but that's not what the statute requires. The statute simply requires that the city make an effort at informing the people to be annexed of the services that will be extended and an estimate of the cost on the landowners. And the trial court went to great lengths in doing that both with police and the streets. On pages 23 through 25 and page 26 of the trial court's decision, again, it took up the streets. And the trial court found, on balance, that looking at the information that the city had provided, that on balance the residents would be getting benefit, and the trial court, taking the deferential view, indicated that it believed that what the city did was reasonable. The trial court concluded with this statement, quote, considering all of these things then, the court cannot say that the decision of the duly elected representatives of the governing body of the city of Basehor was invalid. They acted with authority. They acted with reasonableness. They provided an adequate plan for the extension of municipal services, and the proceedings were regular, and there was substantial compliance with all these requirements. So again, it's the city's position that the trial court did its job under the statute, even without any appellate guidance on the statute that was enacted in 2005. The trial court, looking at zoning decisions, applied that deferential view to this annexation and concluded that it was reasonable and there was substantial compliance.
Can you tell from the decision what standard the court used for determining reasonableness?
Just that it is stated, I think the court's language is, well, it mentions the zoning decisions in its decision, that's where the body of law it's looking at. And I mean, the trial court didn't set out specific criteria about the reasonableness, but did indicate, as I've shared, that, the court does, it's more than a rubber stamp. The court actually used that language. This is more than a rubber stamp. I do look, and I don't substitute my judgment, but I do look to see if it's arbitrary, capricious, and that's what the trial court did. So it's the city's position that the trial court correctly applied the same criteria that have been applied in the zoning decisions, not those specific factors of character of the neighborhood, that type of thing, but it looked at the points brought up by the landowners and took each of those, and for example with the police and the streets, the trial court took into consideration what the city provided and determined that it met the test of reasonableness. Just wanted to touch on a few issues. In the petition for review, the landowners have indicated they were confused about what was being annexed. And I'll just submit to you that in the proceedings below, the plaintiffs never once indicated that they were confused about any errors in the map or the legal description. In their reply brief, in the Court of Appeals, beginning on page 5, there are several pages where the landowners point the court to the prejudice they suffered. But if you look at those pages, really all it amounts to is we're getting a big whopping tax bill and nothing in return. There is no information about, look, we as landowners were truly confused about what was being annexed. So there has been no prejudice cited by the plaintiffs, and this court time and again has indicated that, you know, someone that is alleging procedural irregularities, there needs to be prejudice shown, and there has been no prejudice shown in this case. With regard to I'll just refer to them as the errant parcels, or you'll recall from the briefing there was a little sliver about 2.32 acres that was left off of the map, and then the other error was, I believe it was about 11 acres were included in the legal description when it should not have been included in the legal description. With regard to those parcels, as to streets, which is one of the items that the landowners have asked you to review, there were no streets in those parcels. And if you look at the briefs, the information that the city provided, in assessing what additional cost it would cost the city to maintain the streets, the city measured the streets going throughout the subdivision. And so certainly these two parcels would not affect street maintenance or the city's calculation in that regard. With regard to police, the city also, as noted in the briefs, the city used land area to compare it with the police budget and then take the land area, the subdivision, and by that calculation came up with an estimate of the additional cost for police protection. The city's analysis was it would be about $22,000. Actually, the trial court employed a little bit different analysis just to simply show that there are many ways to do this, and the trial court came up with about $66,000. But my point on bringing that up is this land area, the sliver that was included, or the 11 acres that was included in the legal description in error, that actually, by including that extra 11 acres, the city actually, if anything, overestimated on what the additional police cost would be, not underestimated, which I assume would be if plaintiffs were to point to prejudice, would be that, look, you told us that police protection, it would only be X, but now with this extra 11 acres, it actually should have, so we believe that's a red herring.
What's your response to the complaint about the way the meeting was not continued, it was adjourned, and?
Just as a practical matter, in city business, public hearings normally are not part of a meeting. The meeting may open, but then the body convenes into public hearing, and the purpose of public hearing is to hear testimony from interested landowners. And then normally, before a governing body makes a decision, the governing body convenes back into regular session, and then decisions are made. So I agree with the Court of Appeals that it doesn't seem to make sense that the statute was requiring that during a public hearing that the body actually take a vote. I agree with the Court of Appeals that the statute is simply saying that the body sits and in their hearing the information, they determine the advisability.
And entertains comment, in other words.
Right.
What about the point your opponent makes about additional information coming to light in between the public hearing and then the later action, and the public's inability to comment on the new information?
Well, Your Honor, for one of the plaintiffs was at the public meeting where the annexation ordinance was taken up, and she actually did get up and address the council. And the extra information, again, I don't believe the plaintiffs have not cited any prejudice from what was offered. I think it's simply a point, actually, that was the recent Kansas Court of Appeals case in Pishney versus Johnson County Commissioners. In that case, the same issue was raised, and I think correctly the Court of Appeals indicated that these statutes are not a trap. If there's relevant information that is offered or corrections are made, that's not the intention of the statute to play gotcha with the municipality. Also, in the Court of Appeals, the plaintiffs indicated in supporting their argument that, and they referenced the lake because a large area of this is a lake, and with the Court of Appeals, the plaintiffs indicated that, quote, "there's no reason to believe the lake will generate law enforcement costs," close quotes, indicating that that's sort of the city erred in even considering the lake because that wasn't put in the landmass. But then with this court, now the plaintiffs are criticizing the city for not providing information in its plan about the city's water rescue capability related to the lake. So again, just point this up as an example that frankly, the way the city views this is that it's true. The members of the subdivision did not want to be annexed, and that's very common in these types of things. So it's the city's position that the trial court correctly viewed that and instead of giving the scrutiny to the city's annexation decision that the plaintiffs would like, the trial court looked at it at a higher level and appropriately found that the city acted within its authority and that it was reasonable. Mr. Orr just indicated to you with regard to the city's plan, that it represented a complete lack of information. But I would point the court to the briefing with the Court of Appeals, and within that briefing, you'll find that when Mr. Orr addressed the city council at the public hearing, Mr. Orr indicated, quote, that the plan was a good effort at providing information to the residents. And the city agrees with that position, that the city did its best to provide adequate information to the residents of the subdivision. There was a full public hearing where they were permitted to, as in Clark, they were given an opportunity to present all the information they wanted to present to show the city that this was a bad decision, that the city should not annex. And hearing all of that, the city did annex. So in conclusion...
Do you agree that the city has to enhance the benefits to the landowner in order to annex?
No, I believe if you look at the statute, it indicates they can't fall below. So it's either equal to or greater. So I agree, if the benefits, it was clear from the record in this deferential view that the trial court gives, if it looked like there were no benefits at all and it was just a land grab, then I believe that the trial court in this case, or any trial court in looking at that, would find that this is not reasonable.
So you would define a benefit as staying at status quo but having to pay more money? I'm not sure I understand what you're saying.
Well, as the trial court pointed out, Your Honor, the proximity of the subdivision to the city, the fact that it is a subdivision, it already has been enjoying the benefits of the city. by the proximity to the city, using roads within the corporate boundaries. So I think it's a little difficult just to have a bright line test of, look, you have to show that there are new benefits. As the trial court pointed out, this subdivision has been enjoying the benefits for years from being adjoining the city. The city takes all of its sewer because the subdivision did not have a plan or a way to send its sewer anywhere. So the city has been handling its wastewater for years prior to the annexation. So respectfully, I would ask that this court affirm the Court of Appeals and the District Court in upholding this annexation. Thank you.
Do you have any further questions of counsel?
Yeah, I want to clarify. Are you saying that the Court of Appeals, you keep referring us back to the District Court, are you saying the Court of Appeals was correct for the incorrect reason?
Yes, because I think the Court of Appeals was pretty strident in saying, there's nothing new here. This didn't give us anything new, but I think that's a little bit over-conclude. I do believe, as Mr. Orr mentioned, that the legislature in enacting the statute did believe that there should be a little more oversight, but just not to the extent that Mr. Orr proposes. Thank you.
Counsel, just so I'm clear, you disagree primarily with the result of the district court and how it applied what you would call the correct test?
Well, not only the result, but it did not apply the correct test. It did not make a full review. It actually applied what is already the law and already embodied in the statute. It simply looked at the adequacy of the plan. At page 15 of the decision, it talks about, the trial court said, that still leaves open the question of whether the degree of specificity that was provided by the city was adequate. And so a review of the record that I've made to determine the reasonableness shows that the city's plan was adequate in my judgment. Adequacy of the plan is a different section of 12-538. It did not look at a broad view of reasonableness. It simply looked at another section of the plan and called that the reasonableness. Once again, that would mean the legislature enacted a meaningless provision. Once again, that would mean that 12-538 is internally redundant. Reasonableness means the same thing as adequacy of the plan. That can't be right. That flies in the face of every notion of statutory construction in our state. Moreover, the trial court, with due respect, was wrong. It said there is value given when there's a police department. Ladies and gentlemen of the court, that would mean every annexation where there's a police department is reasonable. And in fact, again, with due respect, the trial court took the cost of police prior to annexation, averaged it over the head count of the people living in Cedar Lake Estates and said that's the value. Well, that would mean, of course, that the more inefficient, expensive, and corrupt the police department was, the numerator of the equation would go up, the more value would be given. That's an absurd result. In short, the trial court did not look at reasonableness in the sense required by the statute, did not articulate a standard, simply reiterated what another provision of the statute already says, and then, again, with due respect, erroneously analyzed the evidence, saying, well, there's going to be some streets, there's value given there. Again, not if you already have streets. Not if you already have streets that are being maintained through a government entity to which you are paying taxes.
How does the prior benefits from the city fit into the calculus? The fact that this area has been utilizing city services in the past.
A couple of points on that, Your Honor. Number one, that isn't in the record except in the most conclusory way. It's just a platitude. For example, what benefits? There's no sports team. We didn't hear anything about the Opera House or the great recreational facilities that people in Cedar Lake use. The people in Cedar Lake have a lake and a community center. They have recreational facilities. In fact, I'm not sure it's clear from the record, and I don't want to mislead the court, But I think the record may show that you get to Cedar Lake Estates by driving down 2440 Highway and then turning on County Road number 2. So in terms of the use of city facilities, I don't see how that's possible or necessary. They could, but there's not much there in Basehor, to be honest with you. And again, I don't know that it's in the record, but so I don't want to go too far afield, but this is very close to Bonner Springs and very close to the Legends in Wyandotte County. So there are lots of shopping and other amenities available in this area that have nothing.
Counselor, that answers why you think there weren't benefits. My question is, if there were benefits in the past or existing benefits, how does that fit into the calculus?
If there had been,
When you're doing the cost-benefit analysis, if they already are getting some benefit from the city, does that fit into that analysis?
it could if it was, I suppose, if it was a direct benefit, but under the same logic, the city of Kansas City, Missouri could be exacting or could try to annex into Johnson County, Kansas. Now, obviously, that's legally impossible. But it'd be hard to say that people in Johnson County, Kansas don't derive benefit from the cultural, athletic, and similar opportunities that a neighboring city provides. There's really nothing in the statute, though, Your Honor, that says how we do that calculus. More directly, there's nothing in the record that says that calculus exists. And that's really the critical point. I suppose if the record had said the only way to get here is to drive through city streets, maybe there'd be an argument. But it's not a very strong argument if the city just builds a street to the subdivision and says, now you need to pay for it. That's kind of a, to be colloquial, a bit of a ripoff. In short, there's nothing in the record that supports that, and in short, I'm not aware of what those would be. Thank you.
Before you sit down, counsel, I have another question.
Sure.
There's been discussion about reasonableness,
Yes.
and your opposing counsel was suggesting an adoption of some of the golden factors taken from the zoning case law. And one of those factors is factor number 6, and it says, action is unreasonable when it is so arbitrary that it can be said it was taken without regard to the benefit or harm involved to the community at large, including all interested parties, and with so wide of the mark that its unreasonableness lies outside the realm of fair debate.
Yes.
Is that somehow in your calculus for the district court to determine what is reasonable?
No.
Or do you disagree with that?
I don't disagree that that's the standard that this court has articulated in zoning cases. Those are a different creature. And there's nothing to indicate that the legislature wanted to adopt the golden factors. In fact, if I recall the history of golden, Your Honor.
Well, let me cut you off.
Well, but there is a thread that, let me answer your question more directly. I'm sorry, I interrupted.
Well, I want to make sure you
apologize, Chief
understand my
Justice.
question.
Yes.
Okay. He was suggesting that some of the language from the golden factors would be applicable in annexation actions, a review by the court. For example, he talked about a presumption that the authority acted reasonably. The landowner has the burden of proving unreasonableness by preponderance of the evidence, and so on. I'm asking whether you have an opinion on whether factor number 6 from golden, which understandably relates to zoning decisions, has any bearing on what you're talking about today.
It does in one sense. It does in one sense, and although that language uses somewhat dire adjectives, so far beyond the mark, dire descriptive words. But clearly that language, and I think it was reiterated in the Zimmerman case that the city cites, does suggest that a cost-benefit analysis is appropriate. You have to look at the overall costs and overall benefits. That's the thread of commonality that I can see. And I say that, Your Honor, because clearly it's looking at the benefits to the broader community. It's talking about benefits. And then again, when we go back and look at the annexation statutes and the drumbeat of history, the annexation statutes repeatedly talk about what are the landowners going to get. I think the theme is, are they going to get benefits that are commensurate with the costs that they're incurring?
Well, the language in this factor says it can be said that the action was taken without regard to the benefit or harm involved to the interested parties.
Exactly.
So my question to you is, are you saying that even though there appeared to be some review of cost-benefit factors made by the district court, you're saying, well, I'm still saying practically that it was taken without regard to the benefit or harm?
Well, it was taken.
That his efforts were miserable failures.
I wouldn't
I understand.
phrase it quite that strongly, Your Honor, but
would you
we're
agree
failures.
that, would you agree that there is some evidence in his order and in the record that he did make some effort to do a cost-benefit analysis? Or would you
flawed.
not?
I would characterize it as a mathematically and legally flawed effort. But yeah, he did say, I'm going to look to see if there was value given, but then the analysis falls apart. And there is not, repeat, is not a defensible cost-benefit analysis. There is no statement of here's what you're getting and here's what you're paying, and that makes sense.
So your response to my question would be, in your view, although he made some effort, practically it was taken without regard to the benefit or harm.
That's exactly right, yes.
All right. Thank you.
And-
Sorry it takes so long to get to that point,
Well,
Judge.
no, that's quite
Justice.
all right.
But are you suggesting that we would not in any way define how to determine reasonableness?
Well, I think it would be enormously helpful if you did define it.
And what would you suggest that?
I would suggest that, as I say, the imposition of the burdens must not be outweighed. Pardon me. That the benefits must at least be equivalent to the imposition of the burdens. Clearly not the case here. That's, I think, the starting point, the cost-benefit analysis. A second analysis would be to read the statutes and pari materia, to read the 16 factors and determine if both substantively and procedurally those factors are met. For example, when it says, what is it going to cost, the annexation? What will be the cost to provide police services? There needs to be some data in there that says, we're going to spend X number of dollars hiring 2 or 3 patrols to patrol this area, or something like that. Similarly with streets, we're going to have to do a mill and overlay in 5 years, and that costs however many thousands of dollars per mile. There has to be something in there so that you can actually reach that calculus. So again, the data isn't really there. What data there is startling in demonstrating that the burdens greatly outweigh the benefits. Thank you.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.